Hello, thank you for joining us. My name is Charlene Crow. I'm here with my colleague, Lindsay Stadler. We are attorneys at Dorsey and Whitney. We practice primarily in the US, but have a lot of experience internationally as well, prosecuting trademarks, clearing trademarks, and working in other aspects of IP. So our job today is to take you through a discussion on trademark basics. We will give kind of a general overview of IP and then dive into more of just the trademark portion of IP protection, and hope to give you some fundamentals to help you as you continue on your business journey. So we'll get started. So let's start at the beginning. What is intellectual property? So there are different types of rights that cover your service or your good that you're offering through your business, whether it's a consumer product or maybe consulting services or something else. They generally fall into 4 different buckets. So you have your patent protection, trade secret protection, copyright protection, and then trademarks. This isn't an exclusive list, but it's the big 4. Patent protection, patents generally cover new and non-obvious inventions. They can cover things like mechanical tools, electrical circuits, plants, other things. Patents exist only after you register them and you have a granted patent. They don't exist before that. Trade secrets are information that you basically keep secret from others that has economic value. So this, I think the big example of this one is like the Coca-Cola recipe. So to have a trade secret, you can't really share it with others. You could do so under an NDA, a non-disclosure agreement, or some other type of agreement where people agree not to share the information. But the more you share it, the more at risk it becomes of being further disseminated or disclosed in a way that would make you lose your rights. So the value is in the secret. That's right. And I think that what you can probably tell from this is that the idea of patents and trade secrets are completely opposed to each other, right? So like a patent, you have to file to have protection, which means you have to disclose your invention, and a trade secret, you have to keep secret. So you really can't have both. You could have parts and pieces. But again, the idea of the Coca-Cola recipe, keeping it secret, that is where the value lies, never expires. Copyrights. So copyrights are the expression of an idea. It doesn't protect the idea itself. This is where you think about books, photographs, architecture, some types of architecture. Software is the subject of copyright. Copyright generally exists without a registration, but in most jurisdictions, you would need a registration to enforce your copyright, including in the US. Internationally, many countries have adopted the Berne Convention, which provides copyright rights to people who have developed copyrights not in the jurisdiction in which they are located. So also a powerful tool, powerful weapon in the protection. And the last one of the big 4 is trademarks. And that's what we'll talk about today. Those are the identification of a source of a service for a product. The identification of source for a product or a service. And those too exist from the moment you create them, sometimes requires registration. But that's what we're going to get into today. So Lindsay, do you want to take us through what a trademark is more specifically, more detailed?
Absolutely. So what Charlene alluded to is a trademark includes brand names, logos, slogans, and even product shapes, colors, smells, and sounds. That all attribute a type of product with the source of that product. So if you think about, popular things like Disney is a brand name that associates with numerous services and goods from the Disney company. There's a lot of different features that could qualify as a trademark. So as you're thinking about how to develop, your company and your brand, it's important to think outside the box, more than just a name. What about your product is unique? What can signify to the consumer that this product comes from your company? That can be the brand name, that can be the shape of the bottle. There's, the trade secret for the Coca-Cola recipe, but there's also a trademark around the very unique, distinct shape of the Coca-Cola bottle. There's the smell. Think of Chanel No. 5, the perfume. That distinct smell correlates back to the source, Chanel. There's sounds like the NBC chime, even patterns, that come from fashion houses like Burberry, and even the overall appearance that kind of correlates across all of your products like Apple. All of their computers and phones have the same similar distinct style that relates all back to the source of Apple.
So it's like McDonald's too.
Yeah.
Has the restaurant drink.
Yep.
Right.
And the whole point is consumers will see this and say, oh, that looks like a McDonald's store. And then they'll relate, okay, so this is the food, this is the reputation, this is what I can expect if I eat at this restaurant. This is what consumers and the consuming public have come to associate with McDonald's.
Yeah, and I would say trademarks probably are more important for protection when you have a product that isn't protected by some other thing like patents. So if you have no fence to keep people away from producing an identical product via, for instance, patent protection, the only thing you have in the market to distinguish yourself from the next person who might come along with a similar product is your brand and the goodwill behind that brand and the quality of that product. So
absolutely. So when you think about, developing your company name and your product, what you want to have as the source identifier, what you want the consumer to associate with your company, you kind of want to think about the company name versus the product name. And there's a lot of public relations considerations that come into this, how you want the public to associate it. One of the best examples is Alphabet is the name of Google's parent company, but almost exclusively people associate Google with the source of the search engine. So you kind of want to think about, what is your company name versus what is the name you want to share with the public as the general, brand identifier associated with your source.
And they might be the same and they might be different.
Absolutely. So as I mentioned, trademarks are used by consumers to identify goods that come from a particular source. One of the key things to think about as you develop this trademark is how the public uses that trademark. A trademark and that comes from you. It starts with the company and how you use the mark itself. So trademark should always be used as an adjective to modify a noun. A noun is the generic name for the product or service. So one of the key takeaways we want you to take away from this part of the presentation is pair your brand name with the generic name for what the goods are. For instance, Oracle is the brand name covering software goods and services. So you should always use the brand Oracle with software. I think a lot of people have, it's a big issue for companies in that people start to associate a brand name with a noun. The key, example being Google. Most people say, oh, just Google that, or, type it into Google. Well, what is that? Now Google is becoming synonymous with a search engine, and it's losing its distinctive ability to identify the source of that one search engine. So you say Google it, and someone might go type it into Yahoo. And therefore, Google is now becoming the name for a search engine. So by pairing the brand adjective with the noun, you're kind of sacrificing that noun generic term to help people understand what your goods and services are. You want to instruct consumers while protecting the strength of that brand name.
And I would say so two extra points here. One is this is particularly important when you have a very innovative product. So if you launch a product into commerce that no one has seen before, which is hopefully happening for a lot of you who are listening to this, it's a first to market product. If you don't give the public another name for that product that they can pair, then every product that comes after you is going to be called by your brand name because that's the only thing people know to call it. So examples of this are things like escalator, Xerox became this way. I wouldn't say they were first to market, but they were definitely biggest. So rollerblade is an inline skate. But when other people started marketing inline skates, everybody started calling inline skates rollerblades, regardless of what brand they were. That's called genericide. You really don't want that to happen. As Lindsay mentioned, Google is at risk. Xerox was absolutely at risk because people would say, go make me a Xerox, not go make me a copy. Another example, Kleenex. Can I have a Kleenex? No, I would like a tissue. So it starts from the company. The company has to do the right branding. So you would never say, use the Oracle. If you were talking about Oracle software, you would say the Oracle software. You would never call a microprocessor an Intel, like the Intel. You wouldn't say that. So just remember that as you're choosing your brand, especially for an innovative product. It's important. You can put your rights at risk.
And consumer education begins with the company. You want to teach your consumers and the public how to refer to your name to protect your brand so that it doesn't become weakened by saying, go Google that, when in fact, Google might apply to your source, not Yahoo or any other search engine.
Mm-hmm. One other thing I'll say before we move on from this point is there is a distinction between trademarks and service marks. The only real distinction is that one references a good, that's the trademark, and a service mark is a brand you use to identify a service. We're going to use the word trademark generically throughout this presentation. All of these concepts apply equally to both. When you are talking about registration and notice symbols, which we'll discuss in more detail later, you can use an SM for a service mark and a TM for trademark, but generally in most jurisdictions, you're not required to use SM for service mark. You can just use a superscript TM, and the world will know that you claim rights in something as a trademark or a service mark. Okay, so we've talked about what a trademark is. So how do you go about selecting? You have your widget, you have your software, your product, whatever it is you're going to take to market. You now know that you want to select a brand for it because you know that it's important. How do you select a strong trademark? So I'm going to talk about the concept of what we call in lawyering as the ladder of distinctiveness. And this is the idea that not all trademarks are created equal. Some are weaker and some are stronger. The words I'm going to use now to describe this spectrum generally apply in most jurisdictions. They might have different wording than what I'm going to say here, but the concepts are applicable, both in registration and in enforcement suits. So at the very weakest end of the spectrum, we have generic marks. These aren't really trademarks. These are just words that are generic names for products. So if I'm selling apples and I call my product Apple, I have no protection. And the reason for this is as consumers, we need everyone to be able to use the generic name for their product so we know what they're selling. We're not going to give people rights in that. So those are no protection. Just a step up from there are descriptive marks. Descriptive marks are trademarks that tell you something about the product or service directly. So best computer service might be descriptive, at least the word computer services. It describes what I'm doing. That may actually be generic too. So those are weak also marks. In most jurisdictions, you cannot protect them until you've used them for a long period of time. In some jurisdictions, you can't protect them at all. Certainly difficult to register, if not impossible. A step up from there is a suggestive mark. This is a trademark that suggests something about the product or service indirectly. So descriptive is a direct association. Suggestive is an indirect association. An example here could be something like a Duracell battery. So Duracell suggests to you that there is something about this that might be battery related, might not be, but doesn't tell you directly what the product is.
Yeah, suggestive marks kind of take a leap of imagination to connect what the mark is to what the goods that mark is branding. And so there's something about the mark that might make you think batteries when you think of Duracell, but it's not immediately descriptive of durable batteries, which is weak in and of itself.
That's right. That's exactly right. Coppertone for sunscreen might be another example of that. A step from there is arbitrary. So these are words that exist in the language in which the trademark exists that have no relationship to the product or service. So here, if I was selling computers and I was using the name Apple, this would be an arbitrary mark because I've taken the word Apple and I've applied it to a product that it bears no relation to. This is a great, strong mark. The very strongest marks, though, are fanciful ones. Those are the ones you make up. They're the coined terms. They're strongest because they bear zero relation to the mark, and the public actually has no idea what you're selling at all. These are the ones that require the most marketing expenditure because nobody knows what you're selling, and you have to tell them. You have to educate the consumer. They are also the very, I guess I would say, easiest might not be the right word, but easier to enforce. Because if someone is using your made up word, it's because they're trying to infringe your rights. If you are trying to create a new brand, I would say go for fanciful if you can. That's pretty hard. Arbitrary is great. Suggestive is probably where most companies fall. Takes less marketing expenditure to get the consumer to come along with you, but it's still not descriptive. And I think that's it for sort of ladder of distinctiveness stuff. So now I know sort of what to do and how to choose it. I think Lindsay's going to take us here in a minute through searching, but I guess a few things to wrap up on those points are the other things to remember in terms of enforceability and choosing the right brand are, one, know what your competitors are doing. Stay away from those marks. Don't do a play on words to get closer to what they're doing. Make your own brand. That's going to be stronger for you and it's going to lead to less problems. If you have a mark that's maybe descriptive, maybe more suggestive, kind of in the middle, but not terribly strong, add a unique design component. Create something around it. This is really important, I think, right now with mobile apps where you need designs. But Nike, I think the Nike swoosh is a good example. Nike isn't a weak mark, but the swoosh has really become a brand on its own, apart from Nike, that identifies the source of their services and goods. And then you want to just avoid terms that describe industry standards or describe the product correctly. So, all right. So Lindsay, I've got my widget. I've chosen my super strong, fanciful, maybe arbitrary brand. I have my logo. What do I do next?
So before you invest too much money in a mark, that means marketing, product development, you actually start printing the mark on a product itself, you want to make sure that you can actually use it without the risk of infringement and that the mark can actually be registered. So this is what we call trademark clearance searching. And there are two considerations that we think of when we're searching for or clearing a mark. The first one is the mark available for use? And this is wrapped up in the affirmative duty to avoid confusion with someone else in the marketplace, another company or source in the marketplace that is selling the same or similar goods under the same or similar mark. The whole premise of trademark law is to avoid consumer confusion. And so if you have a product that is quite similar to another product and similar under the same brand name, there's confusion because a customer might see product A and think, oh, well, this must also be product B. And so we want to avoid that. And that's what we do with clearance searching is we'll look, you can do it yourself. You can do it, in-house, just use Google, look up local registries. We also do, you can hire outside counsel. This is what a lot of what Charlene and I do. We have lots of different resources. We'll go through and we'll look at your mark and see, are there any competitors out there that are using something similar with the mindset of, if you start using this mark, if your product goes to market, are you going to get a cease and desist letter? Are you going to get a claim for infringement? We want to avoid down the road after you've invested hundreds of thousands of dollars in a product, a competitor saying, hey, you're causing consumer confusion. You're trying to pass off as my mark. You must stop doing this or we'll sue you for trademark infringement. So this clearance searching is our way of looking at what's out there, looking at the landscape, and drafting an opinion and saying, okay, here's what this looks like. Here's where your use fits in. Do we think that there's a low risk of infringement? Do we think that you should move on and get a different mark because you might get sued down the road? So it's affirmative, forward-looking clearance search to say, these are what the risks are. If, for instance, we call it knocking out a mark and we find something that could cause you trouble, it's a lot better knowing that upfront, paying the cost for the clearance searching versus paying the cost to redo your marketing, reprint all of your products with the mark on it.
Pull your product off shelves.
Pull the product off shelves, potentially, face a lawsuit for sales of an infringing mark. So this is to prevent getting in trouble down the road.
Yeah, and I think it can't be overstated that even when you've chosen what you think is the brand that's going to be perfect for your product, don't commit to it too early. Be flexible. Sometimes a tweak in the way that the mark is laid out, the format, switching letters around could even help. So I would say be flexible and don't commit before you go ahead and run some clearance searching to understand who else is out there.
Absolutely. And the second consideration, that we look at during clearance entry. So once we figured out whether or not the mark is okay for use, it's can the mark be registered in the applicable, country or locality? Can you, if you file an application for your mark, can you get it registered? Or are you going to run into multiple hurdles on the registry that could cause increased costs because there's a lot of hurdles that you have to jump over without a guarantee of success? There might be some things, some other pre-existing marks that stand in your way that you might, we'll apply for the mark, get all the way through, and the local examining office says, sorry, I'm not going to register your mark. And then that's all the money down the drain and you have to start over. So, Jillian, can you tell us a little bit about what registering your mark means?
Yeah. So it means different things in different countries. I guess I shouldn't say it that way. Each country has its own registry. Generally means the same thing in those countries. In some jurisdictions, you don't need a registration to have rights. I would say in most jurisdictions, you do need a registration to have rights. The one exception to that is where you have a well-known or a famous mark. So the one that comes to mind for me that I see published a lot on India has like a publication of well-known marks that they publish every year. South Korea has a publication of like often knocked off marks that they publish every year. So that kind of correlates to a well-known status. But Samsung is often on that list. Gucci, Versace, and a few others are often on those lists. If you don't have that mark, which when you first launch a product, you probably don't, you're going to need a registration. There are a few countries that have common law systems where they will look at who was first to use as opposed to who was first to file. The US is one of those. Canada has a common law system. India, in the case of looking at registration and who gets priority or enforcement and who gets priority, India will sometimes look at who used first, sometimes not even in India, but who international used first and who owns the rights. In some South American countries, there are systems where they look at other jurisdictions to see who used first. I wouldn't count on that. I would say you're launching a product and the brand is important to you, registration is going to be key. And I would absolutely consider doing that. So as I said, each jurisdiction has its own registry. There are a couple of systems where you can get more than one country in a registration. The EU-IPO is probably the best known registry, and that one covers all European Union member countries. So one filing, one application, one registration covers all member countries. It's examined, but not for conflicting third-party marks. And the reason is, and they call that relative grounds for refusal. So there's no relative grounds for refusal at the EU-IPO. The reason is they can't search every member country registry, particularly when you're thinking about foreign translations and things like that, and issue you refusals based on those. So in the EU, the owner of a prior right in the European Union has it's basically their obligation to oppose your application. You won't be rejected based on them. So when you file the EU IPO, you can automatically have a higher rate of opposition filings. We see that quite a lot. One of the other systems for filing and getting more than one jurisdiction is OAPI, that's the African Intellectual Property Organization. It covers some African jurisdictions. And then there's another one in Africa called ARIPO, which is the African Regional Intellectual Property Organization, covers some of the same and some different African countries than OAPI. We don't file there often using those systems. We usually use national applications, but those do exist. And then the other one to think about is called Madrid Protocol filings. So these happen at WIPO, at the World Intellectual Property Organization. You can file an application at WIPO. You can designate member jurisdictions, so those countries that have become a party to the Madrid Protocol. And you can say, I want to file this application. I'm going to select these 15 countries that I want to designate. That filing requires that you have what is called a basic registration or basic application in a country that's a party. So let's take the US, for example. If I have a US application, I can use that application to launch an application into WIPO under the Madrid Protocol. I can designate India, China, Australia, New Zealand, EU-IPO, all the European Union member countries. And they will examine that application and then they will send it to those countries for examination. The unique part about this is you don't need a lawyer in those national jurisdictions. For that reason, it can be significantly less expensive. The other unique aspect of it is you have one registration when you're done that is renewed on a 10-year cycle. If a jurisdiction has use requirements, like Mexico has a use deck requirement, Philippines, the US, down the road from registration, you will have to file those declarations as well, but the registration will renew all at the same time for all of those jurisdictions. Once it gets to the jurisdiction you have designated for examination, if you receive a refusal in that country, so I said I filed in China, Australia, UIPO, New Zealand, India. If I receive a refusal in India, I have to engage local counsel to help me with that refusal, which you would have to do if you filed nationally anyway. But if you have a fanciful mark that you created yourself, you feel as though it has a good shot of a success, you might try a Madrid protocol filing. Also, if you're tight on budget, it can be a good cost saving.
Should you engage local counsel to file the use declaration, like you mentioned in Mexico, 5 years down the road?
Yes, you should. I think you don't have to, but you will often run into issues with acceptance if you don't do it quite right. So also a good thing to do. So the other way to file in each jurisdiction is just to file a national application in the countries you're interested in. And they are examined on their own merits in those jurisdictions and you receive feedback. When you do that, as a general matter, even in the US, you have to use an attorney that's registered in that country to make those filings. This is a lot of what Lindsay and I do. We have a network of local counsels we use, and we file all over the world in many, many jurisdictions. So that's basically registration. I would say that once people ask us all the time about registration symbols. So when can I use the circle R? What do I use before the circle R? So the circle R can only be used to identify registered rights. In some jurisdictions, they have criminal penalties for using a circle R before you have a registration. I've never really seen that enforced, but it's definitely a tack on for claims if someone's coming at you for other things in those jurisdictions. So the circle R only after you have a certificate of registration in hand, not after approval and not after publication, but actually the certificate. Before that, you will want to use the superscript TM or SM for a service mark if you want, to identify to others that you claim rights in this word, this logo, the trade dress, whatever it might be. So after you have your registration, you have to maintain it. And as I said with WIPO, it's generally a 10-year renewal cycle. Most jurisdictions are 10 years. Canada was on a 15 and they just changed that, which is really great. So it's a 10-year cycle. In the US, you have use declaration. That's due between the 5th and 6th year. And then it's renewed every 10 years after registration. Mexico has a 3-year use dec deadline, I believe, and the Philippines does it as well. There may be other jurisdictions that have use declaration requirements, and the local counsel you're using to help you with these registrations should be able to tell you that information, or it may be in the registration certificate as well.
It's important to maintain these deadlines, though, and make sure that when they come up, you're prepared to show use and maintain the registration. A lot of what Charlene and I do is set out reminders to clients, send out reminders to local counsel, just so that it's on top of mind, because the worst thing would be you get to the renewal deadline and you haven't used the mark, or you don't have the materials to prove that use, and renewal deadline passes and you lose that registration.
Yeah. The other thing to think about is, don't file too early. I would say make sure you've settled on the logo as it will exist, on the brand. If you're filing in color, make sure the color is settled. You cannot easily amend applications in most jurisdictions. I would say the US is probably one of the easier ones to amend in, and still not that easy. Little things like removing a space or a period, those can be done with relative ease, though some jurisdictions will not allow you to amend at all. So you want to make sure you get it right.
The EU is pretty strict about that.
Yeah, they are. So make sure you have something final before you go ahead and register. So a little bit of strategy for registered protection. Lindsay, you want to tell us about how you would think about where to register?
Yeah, so we've talked a lot about the different country requirements, what happens, if you file with the EU IPO or the Madrid protocol. But one of the key considerations for a business trying to launch their brand is, where do we file? There's so many options. How do we narrow it down? If you were to file in multiple, dozens and dozens of countries in the world, you're looking at an exorbitant fee. So what we like to tell clients is generally start with a 3-year look. How are you going to be using this mark 3 years down the line? And then in terms of narrowing the geographic scope of where you want to file this mark, we tend to advise clients to look at where they're sourcing the materials from, where they're manufacturing their goods, and where they're selling. So if you source your materials from Vietnam and you manufacture in China, but you sell predominantly in the EU, it's a good initial strategy to maybe file in those 3 countries. The reason we want to file in countries where you source your goods, you source your materials and manufacture your goods, even if you're not necessarily selling there, is protection in terms of your manufacturing relationships, your sourcing relationships. Just in case the relationship goes sour down the road, you want to make sure that you own the brand. Charlene mentioned a little bit earlier about first to use versus first to file. And these first to file jurisdictions are first person to file the application with the respective registry. And so what happens is there are a lot of squatters in those rights who may say, maybe you have a manufacturer who might not be the most trustworthy, and they file for your brand in China before you do. They have rights in that. And then canceling their mark is difficult. So what you want to do is have a manufacturing relationship where you own your brand, you have a good agreement with them, you have a good licensing agreement with them. But should the relationship turn south, they can't take the ownership of your mark and go, slap that brand on a bunch of different products. So that's how we kind of think about the back end distribution and development of your product, as well as while you're selling it.
Well, and in those jurisdictions where you're manufacturing and sourcing, people start to know your brand, even though you're not selling there. And if it becomes a big brand, they may just file to be sort of opportunistic, right? So it could be someone who's not even related to any relationship you have, who's squatting on the rights and then trying to get you to pay fees to get it back. Or a worst case scenario is going after you and, shutting down a factory because you're infringing their rights, which can be tricky and can happen in China, I would say in particular. There are companies in Asian jurisdictions in particular who watch the US registry for filings by certain companies or anybody, and then they go ahead and eat up those rights in other jurisdictions. So I would be a little careful there, as Lindsay said, especially in the first to file jurisdictions.
So after we kind of think about where you want to file your mark, we also want to think about what the company's goal with that mark is, and namely how long you plan to use that mark. If you have a brand for the company itself that you intend to use for the lifespan of that company and in relation to all of the products, that is a good mark to register in those places. However, if it's a line item name, if it's one product that might have a lifespan of a year, we generally would like to, we try to look at whether or not it's prudent to file that. Because in most jurisdictions, from the time of filing to the time of registration, we're looking at a year or longer. And so if you use a mark and you only plan on distributing that t-shirt or this one particular widget for only a year, by the time you get the registration, you might already be moonlighting that product. It doesn't make a lot of sense to spend the money on a registration, but by the time you get it, you're not using the mark anymore. So that's why we want to take a lot of, into consideration what the company's goals are with that particular brand. If it's, the big umbrella brand, the brand you tend to use on everything, that's when we recommend filing in all of the countries of interest. If it's 10 years down the line, we really want to protect that mark through, a broad protection plan.
Yeah, and I would say this applies to things like marketing taglines that you may use in certain advertising or for a certain trade show or at a certain time. I would just think hard about whether that tagline has staying power and maybe wait to file it. If it's very important, though, to you and it's very unique, even if it doesn't have staying power, this idea of filing to protect it on first to file registries is a good idea. But just know that if you do end up sunsetting it, as Lindsay said, then I think you may have wasted some time and energy and money on a registration, but sometimes you can't know these things in advance.
Yeah. Talk a little bit about squatters' rights, but how does this affect counterfeits? If someone is knocking off your product or if someone is selling unauthorized goods of your product.
Yeah, I think So without a registration, it's very hard to stop counterfeit products in a lot of jurisdictions. And in jurisdictions where they have gray good restrictions, also hard to stop them without a registration. So one of the reasons to register is to stop counterfeit, to stop imports, to stop gray goods from shifting into a jurisdiction in which you never intended them to be sold for various reasons. That's particularly important for things like pharmaceuticals. If it's not a product that's been cleared for sale in a jurisdiction, you certainly don't want it finding its way into that country. But generally, if you want to stop those types of products, registrations are required.
And then, kind of one of the final considerations is budget. As we mentioned, filing, there are different strategies for filing. We can file with the Madrid Protocol, we can file nationally, but there are costs associated with filing for trademarks in each country. So if your company is young and you have a marketing budget, a product development budget, manufacturing budget, you want to take into consideration what your trademark budget would be so that we're not blowing your marketing budget on trademark filings for countries that you might not be using the mark in ever or are 4 or 5 years down the road. So these are all kind of things that we help clients think about as they're developing a mark, and where after we've cleared the mark, once the mark is in use, where do we file for? Where do we get that protection from?
Yeah, I would. So the typical cost for an application, I would say through to registration, is probably $3,000 to $5,000. We'll say you can get some registrations more inexpensively than that in certain jurisdictions. Certainly in jurisdictions like the Middle East, those are the highest cost jurisdictions. You're looking at upward of $6,000, $7,000, $8,000. I've spent well over 10 in the Middle East. There are super legalization requirements there and other requirements, high filing fee costs, things like that. So you really need to be judicious with the spend, at least in the beginning. The worst thing is to run yourself out of money filing for IP protection so that your launch doesn't go well. Yeah. I think Lindsay and I, if we had $1 for every time someone said, I want to file worldwide, that really is pie in the sky. So we would encourage you, again, to just use those rules that Lindsay set out.
And there are numerous benefits that come with seeking a federal trademark registration or a trademark registration in any country. As Shirley mentioned, upon registration, you're entitled to use the Circle R, which provides notice to third parties that this is a registered trademark. And at least in the US, this comes down to this can be beneficial for damages should you ever find yourself suing someone for trademark infringement. If you have the Circle R, it is notice that they knew that this was a registered trademark and a presumption that they still use that mark anyway. In the US, this provides nationwide protection. So Shirley mentioned there's the first to use nations where you can have common law rights. But those common law rights are limited to a geographic scope. So if you're only selling this product in Southwest United States, your rights associated with that, if it's not registered, are within the geographic scope that you're selling those products.
Same for EU. If you only sell in Spain, it's hard to have rights in the rest of the EU member countries without a registration.
But upon registration, in the EU and the US, you get nationwide protection. So that's saying if you are only selling in New York, but you have a federal registration, you can go after someone in California who's using a similar mark for similar goods. That is the benefit of this federal trademark registration. There's litigation advantages. As we mentioned, there's a presumption of validity, that your mark is valid, that you don't have to prove if you just have common law rights. You can exclude infringing imports. It's a lot easier to stop those infringing products from coming into certain countries if you have proof of a federal registration. And there's just the increased value to your business. If you have a developed mark with a registration, and you're trying to sell the company or merging with company, or that just adds a degree of legitimacy to the brand that you've spent so long working to clear and register and protect. And you can say, we have this trademark portfolio, it's protected, it adds a degree of profitability to our business.
So I think one of the things we see with startups is they're trying to get funding. So they have tranches of, they're giving ownership in the company maybe, or they're looking for private equity because you need money to run a business. And when you're a startup, it's hard to find capital. One of the things you can do by obtaining trademark registrations or patents or other types of IP protection, or showing that you have IP protection and IP savvy, is use that when you are marketing your company for investment or to private equity firms. It will increase the value of the business, the bottom line. It's an asset of the business, and it also shows that you're serious. So it can be really useful in that context. So a few other things to think about as we're wrapping up our discussion on trademarks. So we talked a lot about choosing your mark, choosing the right mark, clearing that mark, and registering the mark. But what are the other sort of things that to think about for trademark protection? And one is to have appropriate licenses. So Lindsay mentioned earlier supply, sourcing, materials, and manufacturing. All of those people, maybe not your supply so much, but your manufacturers, if they are manufacturing a product that bears your brand or packaging it at the site of manufacturing in the way that it'll be sold, they are using your trademark. And if they're going to be doing that, you should have a license with them. That license can be part of the greater manufacturing agreement that governs the terms of how they will do things, how you will pay them, etc. There should be a license of some sort that basically says you get to use this trademark for this reason, and you can't use it for any other reason. And when this relationship ends, you can't do anything with it. Oh, and by the way, you can't go ahead and register for us in the jurisdiction in which you manufacture. In some countries, if you have a license, you have to register it in order for the licensee's use to be considered your use for purposes of enforcement and for other tax purposes. So just know that and remember that as you're working with local councils or companies in other jurisdictions. There might be a requirement to register the license against the trademark registration. I would say if you have a manufacturing agreement or a distribution agreement, when it's also extremely important to have a license, you want to make sure that's a country that you've registered your brand in. You don't want to have those agreements for distribution or manufacturing and not have a registration. Those things should really go hand in hand. When you're thinking about those agreements, just a few essential provisions to keep in mind. You want to identify with specificity the assets that you're giving these folks to use, the trademarks. You want to identify who owns them and who's licensed to use them and the official names of those parties. You want to identify the territory in which that company or that person is allowed to operate and work for you, and the trade channels, if they're distributing product, in which they're allowed to distribute the product. So is this retail, brick and mortar? Is this online sales? Do we have to geo-block for those online sales? Can you have your own website, or are they using Amazon? All those terms should be worked in. What are the goods and services they're going to sell? You don't want to just say clothing if you want to restrict a certain type of clothing from being sold. Maybe it's not on brand. Maybe you sell pants and you don't want to sell some other garment. Right?
Basic t-shirts.
Right. You also want to make sure that there's a restriction on selling other goods. So maybe you sell a great shoe, and this company also happens to make bags for other companies. And they're like, gosh, we could just slap this brand on these products. You want to make sure that doesn't happen. You want a term provision. So this is, when does this relationship start and when does it stop? And how do we renew it if we want to renew it? You want to give yourself a way to get out. If the relationship isn't working, you need a way to terminate that works. Exclusivity. Is this person going to be your distributor in the EU, exclusive to anybody else, even you? Or are they going to be exclusive, but not as to you, and you still get to sell on Amazon and ship to consumers in that jurisdiction? These are all things to think about. And then quality control. You get to check the products they're manufacturing, the products they're selling, to make sure that it's up to snuff. And then you get to tell them when they have to make changes.
You don't want to be lax on the quality control provision and have your manufacturer send out products that might not be up to your standard, and they circulate, and suddenly consumers attribute maybe not a great product with your company. That's, they attribute the brand with the source. And if it's not a very good product, you don't want that to harm your reputation.
That's particularly important if your manufacturer is shipping directly to your distributors, which does happen, particularly as companies grow.
So we threw a lot at you. We know this is a lot of information, but I think some of the key takeaways in order of how you should think about these marks are: first, brainstorm. Sit down with your marketing. This is the creative time. This is when you get to think about the big picture. This is, one of the reasons why I love being a trademark attorney so much is the creativity of, what people want to brand their business and brand their product. They're very excited because they have this great idea, and, this is how they want to represent it to the public. So brainstorm those brands, those marks, the logos, messaging, packaging, and then develop preference lists. As Charlene mentioned before, don't get too committed to one mark. If for some reason we come back and say, you're clearance searching, you can't use this mark. So develop preference lists. You can say, we prefer this mark, but these are other ones that we're interested in. Second would be determining what needs to be protected. These are the unique features we talked about, say with your widget. You developed a widget. What is unique about it that you want to protect? Is it the name? Is it the slogan, marketing tagline that you want to use with it?
The product design itself.
Yes.
The color of the packaging.
Yeah, there's a lot of little things, but think about the unique aspect of it that you want people to associate with your company. Those are things that should be protected. Third would be what we talked about with the clearance searching. Can you use this mark with a low risk of receiving infringement notification, a cease and desist letter, and then can you register it? What are your competitors doing and how do you stay away from your competitors? Because your competitors are likely going to watch what you're doing and you want to avoid any risk with that. We can also, we do a lot of searching in the US, but we also, we do a lot of searching elsewhere. And if this is a mark that you're really interested in, any country of interest, it's a good idea to just take a look at their registry and say, are you going to run into any hurdles? That's, we do the clearance searching before we get to step number 4, which is registration. This is where you determine the scope geographically, where you want to file for based off sourcing materials, manufacturing, and the sale itself. This is applied to, what is the product and the service? How long do you anticipate using this product? What is the launch time? Is it worth trying to register the mark for a product that you're only probably going to use for a year? So you want to prepare information required for the application and registrations, the dates you first started using it, how you're using it, and we call those specimens. Specimens are required to show how the mark is being used in connection with the product and services that you're seeking to register for. And then we proceed through to trademark registration. We mentioned some jurisdictions are quite quick. The EU is probably 3 months, 3 to 4 months. While some other places like Canada are 18 months.
Brazil is 5 years.
Yeah, it's a very long time. So as we mentioned, it's a consideration timing-wise. If you only plan on using the mark for 3 years, some countries like Brazil or Canada might not be the best investment. And then finally, the last branding process that we look at is use, policing, and enforcing. This is using the circle R next to the marks that have been registered. This is the licensing and ongoing employee and vendor education. This is the marketing to keep your mark from becoming generic. If you come up with Oreo, don't just say Oreo all over the place for marketing. You want to say Oreo cookies so that people don't associate cookies with Oreos that don't come from you and that are not Oreo branded cookies. You want to adhere to your own branding guidelines. You want to make sure that any manufacturers or third-party licensees that use your mark follow your strict guidelines. This is in relation to quality control for the product itself, but you also don't want someone, your manufacturer, accidentally using your mark plural or in a different color than the logo that you have. You want to make sure that they're using the mark the way you want to use the mark. And then there's a lot of different considerations when it comes to avoiding lawsuits. So you want to avoid your clearance searching, you want to avoid your own infringing of someone else's, but you also want to protect your mark. And that means going after people that are infringing it, that are trying to trade off of your goodwill, they're trying to represent their product as your own product. And that's when it's appropriate to consider filing an action or sending a cease and desist letter to protect the strength and the reputation associated with this brand that you've invested so much money in.
And I would say it's not even just civil actions. You can take action at the registries to stop people from registering similar marks. So definitely a good idea to watch the registries. That's a great wrap up, Lindsay. She just took you through what we took you through in this whole presentation in just a short couple of minutes there. And I think that is the right layout and the right process to use. In terms of resources, I would say if you go to the uspto.gov, you can find, it's US-centric indeed, but it also applies generally to a lot of different jurisdictions, the concepts. They have a lot of information just about trademarks generally, about how to protect them, about what it means to have a trademark. The EU IPO, if you just do a Google internet search. Don't Google it. Do a Google internet search. You can find a lot of information on the QIPO about their registration process. Nearly every registry has a website, and you can go ahead and research on those sites to find more information. Some of them are in the local language that can make it a little difficult. In terms of registration, just to wrap up, the key is, the filing. It gets examined by people at the office. They tell you if it's rejected or not. You have a chance to respond. It's published, so third parties get to oppose. This relates back to what Lindsay was saying with enforcement. You could oppose someone else's mark, and then a registration will generally issue after that. The examination and the publication may take place in different orders. In South America, publication usually happens first, and people get a chance to object. Most other jurisdictions, publication happens second. So that's what takes that long time, that whole process. But go ahead and find those resources online. There's plenty of information out there. And of course, Lindsay and I are at Dorsey and Whitney. Reach out anytime. We'd be happy to help too.